hatred and extremism, and we proclaim the imperative for the international community to take immediate and swift measures to end the massacre and the targeting of Palestinian civilians so as to confirm that there's no difference between one life and another, nor discrimination on the basis of nationality, race, or religion. Those are the conditions without which no lasting peace is possible. We also expect your court to condemn the accelerated colonization of East Jerusalem, as well as the Israeli attacks conducted against Islamic and Christian holy places at Al-Quds. So therefore we hope that the advisory opinion you will render will be an opportunity to recall under your authority the imperative duty incumbent on Israel, the occupying power, to end its occupation of Palestinian territories prolonged for far too long, and to repair all the consequences. And now our counsel, Madame Chemillé-Gendreau, to whom I respectfully ask you to give the floor, Mr. President, will set out the legal aspects on which the Organization of Islamic Cooperation believes it can provide some further clarification. Thank you.
Yes, thank you very much, Mr. Taha. I now invite Madame Monique Chemillé-Gendreau to the podium. You have the floor, Madame. Yes, thank you. Thank you, Madam, Mr. President. It's on behalf of the Organization of Islamic Cooperation that I have the honor to appear before you this morning. I'm going to look at three elements of the situation which lie at the heart of your opinion. Now, some of the participating states in the instant proceedings requested your court to decline your jurisdiction. They were of the opinion that the request for an opinion would upset the negotiations purportedly underway between the protagonists, and that these negotiations were the only way towards peace. But let's have a look at the facts. Let's establish them in their truth, because that's an indispensable condition for justice to prevail. Now, are there negotiations underway between Israel and Palestine? The truth of this question is that there aren't any more. This is a myth which has long been artificially maintained, but which, if you look at current events, has totally collapsed, and even the parties involved admit this. Is the court in a position to establish truth on this point? Now, some participants in the instant proceedings have argued that you should decline your jurisdiction on account of some supposed difficulty to access the facts. But the case file that you received from the services of the UN themselves have all the elements you need on which to base the opinion requested. Thus, it is a known fact that the Oslo Accords, dating back to 1993 and 1995, that their objectives were intended to be achieved by 1999 at the latest, and that this time frame has not been met, and that subsequent meetings held in Sharm el-Sheikh in 1999 and Cape David in 2000 bore no fruit. From then on, neither the redeployment of Israel nor the consolidation of the Palestinian Authority's autonomy has come to pass. The outlook for the Oslo Accords hinged on compliance with resolutions 242 and 338 of the Security Council, where they are explicitly mentioned. This compliance required the withdrawal by Israel from occupied Palestinian territory in 1967. Article 18 of the Vienna Convention on the Law of Treaties provides that parties to an agreement must abstain from acts which deprive the treaty of its object and purpose. Thus, Israel's accelerated settling of Jewish colonies on Palestinian territory has deprived the Oslo Accords both of their object and of their purpose. Israel's politicians have confirmed the demise of negotiations when they denounced the Oslo Accords as of the year 2000. That's more than 20 years ago. At that time, Ariel Sharon declared to the Haaretz, I quote him, "We're not going to continue Oslo, no more Oslo, Oslo, it's finished." End of quotation. More recently, on 12 December 2023, Prime Minister Benjamin Netanyahu asserted, I'm quoting him, "I shall not allow Israel to repeat the mistake of the Oslo Accords." End of quotation. Your court will recognise that we are confronted here by a particularly noteworthy breach of good faith. Israel is a member of the United Nations. It's bound by the resolutions of this organisation as well as by specific undertakings it made. Yet it rides roughshod over the entire body. The state in question appropriates Palestinian territory, expels its people, denies Palestine the right to self-determination by all means available. You recalled in your judgment of 2018 that when states engage in negotiations, I quote you, they must conduct them in good faith. End of quotation. Well, it would appear that Israel's good faith vanished shortly after engaging in the Oslo negotiations. Thus, no negotiation on the horizon right now which needs protection. Just an ongoing war and the refusal of Israeli authorities to open any political perspective based on international law. That's why the argument whereby a finding of jurisdiction to give this opinion would in some way bar the way to a negotiated peace is an argument wholly without merit. Now, this is my second point. I'd like to dwell a little longer on the question of negotiations to make a substantive remark here. Palestinians will not recover their legitimate rights by direct bilateral negotiations with Israel, and there are two reasons why not. The first relates to the overwhelming inequality between the two parties. Palestine is under Israel's military domination, and its representatives find themselves in a position of structural weakness. As such, any negotiation will be biased, and the resultant treaty will necessarily be unbalanced. The second obstacle relates to the fact that in negotiations which have taken place up to now, Israel has attempted to make the Palestinians make concessions to the fundamental rights they have under international law. The principal violation, which is the source indeed of the other violations, lies in Israel's persistent refusal to let or to give the Palestinian people the right to self-determination. At no moment since the end of the British mandate in 1947, has Israel's leaders admitted with sincerity that a Palestinian state could coexist with them in Palestine. Israel's Prime Minister confirmed this on 20 January to his opposition to any Palestinian sovereignty. When Israel pretended to negotiate the Palestinians' right to statehood, it was only to concede a caricature thereof, demilitarized power, enclave, dispersed over a fragmented territory, with reduced access to its own natural resources. And yet, the right of peoples to self-determination is a just Kogan's norm. It is not some constitutive right which could only arise if recognized by Israel. Not at all. It's a declarative right, inherent to the situation of the colonized people of Palestine. And it exists from the moment this people, the Palestinian people, decided to claim it. Thus, purely and simply, this is not a negotiable right. Israel has occupied, as of 1967, Palestinian territories subsequent to a military action which was carried out in breach of the core rule prohibiting the use of force. So Israel is occupying a territory over which it has no right. Israel must withdraw. And that's not negotiable either. By colonizing this territory, Israel breaches the prohibition of transferring population from the occupying power into the occupied territory. And Israel's official plan is to continue this unlawful act. From the 700,000 currently on the West Bank and in Jerusalem, the settlers should pass the million number as fast as possible, according to Minister Smotrich. That's what he said on 12 July 2023. So Israel has officialized this breach by including in its basic law of 2018 the development of Jewish settlements as a basic value of Israeli society. This, notwithstanding that international law requires the dismantling of all these settlements. And here, yet again, we have before us an obligation which is non-negotiable. The security of Palestinians is seriously threatened. They're dying in thousands under Israeli bombs in Gaza since 7 October, and in the West Bank, according to Israeli sources, 367 Palestinians have been killed since 7 October, including 94 children. 2,960 Palestinians have been arrested, and Palestinian sources are of the opinion that these figures are highly underestimated. Settlers in the West Bank and East Jerusalem freely wreak violence against the Palestinians. They're encouraged. They are armed by the state of Israel itself. So the dispossession of their lands and the repression to which the Palestinians are subject to has intensified over the last months, and at the same time a policy of discrimination which constitutes apartheid. All these violations of fundamental rights must stop. Once again, it's not negotiable. To give the requested opinion, your court will have to look at the question of Jerusalem. Now, this city wasn't included in the territory destined to Israel by Resolutions 181 of the General Assembly of the UN, proposing a partition plan for Palestine. When it was admitted to the UN in 1949, Israel solemnly accepted the principles of the UN Charter and the resolutions voted by its organs. Thus, there was recognition that Jerusalem had not been attributed to Israel. However, by taking over the west part of the city by force in 1948 and in 1967 the east part of the city, Israel made Jerusalem its reunited capital in 1980. Since then, East Jerusalem has undergone a forced Israelization via intense settlement. This is considered as irreversible by Israeli leaders. However, East Jerusalem has no other status than that of a territory occupied militarily by foreign power, and like all, indeed, of Palestinian territory occupied since 1967. So Israel has to withdraw in favor of the Palestinian people, as the relevant resolutions of the Security Council and the General Assembly have required constantly. The holy places have to be freely preserved and open to all those who wish to go there. And that's not negotiable either. Disregarding these legal imperatives shared by all nations, Israel would like to legalize its unlawful actions, which I've just mentioned, by placing them in an agreement Yet if one subjects the situation to legal analysis, what becomes apparent is that Israel has no right over Palestine, only duties. And the preservation of international public order based on shared, non-derogable norms depends on their being complied with. The responsibility of this compliance falls to the United Nations, which is mandated with peacekeeping. They have been confronted with Palestine's decolonisation case filed by the failure of the mandate given to the UK. The UN is the only authority capable of resolving on a legal basis the situation created by decades of failure. And if peace must come from an agreement between parties, this must be concluded under the auspices of the United Nations, guarantors of legal compliance, and not under the arbitrary sponsorship of a third state lacking in objectivity. Thus, the way forward, based on the findings of your opinion, should ensure that the agreement re-establishing the Palestinians in all their rights will respect the fundamental norms which currently are the target of circumvention. If that weren't to be the case, the future peace treaty would fall under the Vienna Convention of the Law of Treaties, which provides, I quote, "A treaty is void if at the time of its conclusion it conflicts with the peremptory norm of general international law." End of citation. This brings me to my last point, the second question, which is being put to your court by the General Assembly of the UN. You are asked about the legal status of the occupation and on the legal consequences arising from it. You must thus examine Israel's occupation of Palestinian territory holistically in the light of international law. Well, first of all, it's jus ad bellum, the law which governs the use of force by states. This includes the very important norm of the prohibition of the threat of use or use of force against the territorial integrity or political independence of any state. Now, it is established that it is by the use of force that Israel occupied Palestine in 1967, as the Security Council and the General Assembly have ceaselessly recalled. This use of force directed against territorial integrity and Palestinians' political independence, which is today recognized as a state by the UN. So the occupation was unlawful from the very beginning. This illegality is manifest since 1967 by the way in which this occupation has been conducted. It breaches all the conditions set out in the law of The Hague and Geneva regarding military occupation of foreign territories. These conditions are identified by the manual of the International Committee of the Red Cross. The occupying power may not modify the structure and characteristics, intrinsic characteristics of the occupied territory over which it acquires no sovereignty. Israel has ceaselessly changed these characteristics for its own benefit. Occupation is and should remain a temporary situation. Now, Israel's been occupying Palestine for 66 years now, and its leaders openly broadcast their intention to indefinitely pursue this occupation. Israel must administer the territory in the interest of the local population, taking into account its needs, and the needs of the Palestinians have been cruelly ignored. Israel must not exercise its authority to serve its own interests and those of its own population, yet all of Israel's policies and practices are directed for the benefit of Israeli settlers and in breach of the Palestinians' rights and interests. These are the conditions in which Israel has developed the occupation of Palestinian territory, conditions whose complete evidence can be found in UN reports. And they will lead you to conclude that this occupation, by its duration, by the practices of it, is the pretext for an annexation plan. This, officialized regarding Jerusalem, has been implemented de facto for the West Bank. Well, as for Gaza, total war underway there, and the plans announced by the government of Israel confirm the will of Israel to maintain their mastery over this territory. The result of all this, as your court doubtless will confirm, is that the occupation by Israel of Palestinian territory is triply unlawful. It is unlawful at its source, having breached the prohibition of the use of force. It is unlawful on account of the means used, which constitute systematic violations of humanitarian law and human rights law. It is unlawful by its aim, objective aim, being to annex Palestinian territories, thus depriving the people of Palestine of its fundamental right to self-determination. I'd now like to just give you a few of my reflections to conclude. Israel's unjustified and unpunished use of violence against the Palestinians leads to yet more violence in response, in an infernal cycle, that of vengeance. And vengeance naturally favours the strongest. This is the murderous chain of events tragically taking place as we watch. To break this chain, an impartial third party is needed, authoritatively asserting what the application of a common norm should be. It falls to your court, when you hand down this opinion, to bring all of this conflict back under the spotlight of the law. This law allows you to declare what rules should be applied in a critical situation, but also what measures can be taken when these rules are persistently violated. Let me recall that the submissions of the Organization of Islamic Cooperation remain unchanged with respect to our written comments, but I will allow myself, if that is all right, to refer to two of them. I recall solely that the organisation that I represent requests the court to enjoin Israel to cease the violations which have been pointed out, and to require the UN and their member states to use all measures available to bring the situation to an end, including sanctions against the responsible state. In peroration, Mr. President, distinguished members of the court, I'd like to quote Israeli Rear Admiral Ami Ayalon, who ran Israel's domestic intelligence service for a number of years. Now, his personal path in life has led him to question the concept of the enemy and assess the dead end in which Israel finds itself after having chosen violent repression to accompany its refusal of a political solution. A few weeks ago, he concluded an interview given to a French newspaper by saying, I'm quoting him now, "The international community should play a beneficial role. We need someone from the outside to show us our mistakes." End of quotation. So, saving the Israelis from themselves, that will be the contribution of the international community, thanks to your advisory opinion. Thank you very much for your attention.
I thank the delegation of the Organization of Islamic Cooperation for its presentation. I invite the next participating delegation, the African Union, to address the court and call Madam Professor Hajer Geldish to the podium. Madam, you have the floor. Mr. President, distinguished members of the court, it's an honor for me to represent the African Union, an organization numbering 55 member states. On this last day of pleadings within the framework of the present advisory proceedings, it's important to recall the historical context and the tragic circumstances that prompted the UN General Assembly to request once again and regrettably for the international community an advisory opinion from the court on the situation of the occupied Palestinian territories. Now, the history of Palestine is a history of dispossession, displacement, and of dehumanization. It's the history of an injustice. It's the tragedy of a people who, for over 7 decades, is systematically subjugated and oppressed by the Israeli colonial project, whose aim is to establish total and exclusive control on all of Palestine's soil, to deny the Palestinian people its inalienable right to self-determination and deprive it of its right to live freely in its native land. The ongoing Israeli aggression against Gaza demonstrates this tragedy. A population of over 2 million innocent and defenseless civilians is the victim of a campaign of wanton death and destruction, consequence of the collective punishment exerted by the occupying power for decades. That's why at the conference of heads of state and government of members of the African Union that was held on 17 and 18 February this year, the heads of state and government of member states of the AU expressed, and I quote, their total outrage at the humanitarian catastrophe caused by Israeli forces occurring in the Gaza Strip and their full support for the Palestinian people in their legitimate struggle against Israeli occupation. The heads of state and government of member states of the AU also denounced, and I quote, the collective punishment measures against civilians, especially the attempts to forcibly transfer the Gaza population. Consequently, Israel's aggression against Gaza is nothing but a shameful attempt to create another Nakba, a further catastrophe destined to erasing the Palestinian presence in Palestine. Indeed, barely a few weeks ago, this court recognized the grave peril that the Palestinian people was facing in Gaza when it determined that South Africa, one of the member states of the African Union, had established the plausibility of its allegation according to which Israel is committing genocide. Nothing can justify the unspeakable suffering and horrors inflicted on the population of Gaza. That is the essence of the Palestinian tragedy. For over a century, the Palestinian people is enduring a succession of Nakbas, from the Balfour Declaration to the wars of 1948, 56, 67, and 82, with the establishment and expansion of Israeli settlements and the construction of the separation wall. At every moment of history, the Palestinians have been the victims of subjugation, displacement, and dispossession. The escalating violence and the ruthless war machine ceaselessly devastating the Palestinian population. Schools, places of worship, homes, hospitals are reduced to nothing, leaving behind them only the smoke of bombs that continue to rain down on Gaza. By miracle, children are born under the rubble, but they're living on borrowed time, given the famine affecting them, grieving families, surviving without water, without electricity, and see day after day their hopes, their dreams, and their destiny despairing forever under the ruins. The conscience of humankind will never forget it. Mr. President, members of the court, this advisory proceeding aims at preventing this new injustice resulting not just from the force of arms but also Israeli practices comprising the de jure and de facto annexation of Palestinian territories, the illegal establishment of settlements, the alteration of the demographic character of Jerusalem, and then the confiscation and destruction of Palestinian property, expropriation of Palestinian land, the construction of bypass roads, and maintenance of the separation wall. The fact that these Israeli practices in occupied Palestinian territories are continuing and accelerating is the result of the impunity that Israel enjoys and its breach of the right of people and the just Kogan's norms that are enforceable erga omnes. This contempt is illustrated by the Israeli decision to ignore the advisory opinion of this court regarding the separation wall, or the countless resolutions passed by UN organs that have documented these violations of international law. This instant advisory proceeding is an opportunity to at last hold Israel accountable for its acts, but also to put an immediate end to its impunity and to uphold general international law, international humanitarian law, and human rights law. Furthermore, the African Union is a party to this proceeding because it feels it has a particular responsibility towards the Palestinian people. Its member states emerged from this colonial scourge, waged war against apartheid and racial discrimination, and defended the cause of self-determination. Our presence here today reflects the sentiment expressed by heads of state and government of African Union member states who stressed, and I quote, the centrality of the just cause of Palestine and the steadfastness of our supportive position and decisions based on our shared values against colonialism, oppression and apartheid, and the historically established African solidarity with the Palestinian people in their legitimate quest for freedom and an independent state. Mr. President, members of the court, on the occasion of the advisory opinion of the court on the Chagos archipelago, the African Union saw the authority and impact of the court's decisions. This opinion indeed contributed to almost ending one of the last living forms of colonialism in Africa. As with this case, the question before you doesn't hinge on a dispute opposing two equal parties, but an asymmetrical situation in which an oppressed people is confronted with an occupying power. Therefore, the court will be able to confirm, in the same way as in the Chagos case, the Palestinian people's right to self self-determination and freedom and ensure the state of Palestine is in a position to exercise its full sovereignty and its independence on its territories of the West Bank, Gaza, and on its capital, East Jerusalem. Before humbly asking the court to give the floor to my colleague, Professor Mohammed Helal, I'd like to address the question of jurisdiction. Our observations will be brief. The vast majority of participants agreed that this instant proceeding, that nothing prevents the court from exercising its advisory function. It's a position that the African Union shares fully and totally. Indeed, the court has already confirmed its jurisdiction in a request for an advisory opinion on the same factual situation in the Wall opinion, and it has no reason to divert from that assessment. Furthermore, the jurisprudence of the court has affirmed on numerous occasions that the political nature of a dispute has no incidence on the duty of the court to answer the questions of a legal order put to it by the General Assembly. Moreover, the court has abundant evidentiary material and facts available to it, allowing it to render an advisory opinion. Lastly, the existence of a negotiating process cannot justify by the court the use of its discretion not to render said advisory opinion. And contrary to the statements by certain parties, the opinion of the court, far from complicating this process that's in fact at a stalemate, can but strengthen it by clarifying the obligations and legal consequences for all parties. In concluding, I should like to recall the words of Nelson Mandela a few years after the liberation of South Africa. He issued a warning which concerns us all, and I quote,
"Even our own freedom, we can fall into the trap of washing our hands of difficulties that others face, yet we would be less than humans if we did so."
And it is in this spirit that he spoke the words that continue to resonate in the streets of the whole world today.
It's incomplete without the freedom of the Palestinians.
Mr. President, I now ask you to kindly give the floor to my colleague, Professor Mohammed Helal. Thank you for your kind attention.
Je remercie Madame Geldich. I now give to Mr. Mohammed Helal. You have the floor, sir.
Mr. President, distinguished members of the court, it is a privilege to appear before the court on behalf of the African Union. As indicated by the Legal Counsel of the African Union, I will cover the following issues. I will identify the internationally wrongful acts that are attributable to Israel and address the question of the legal status of Israel's occupation of the Palestinian territories. Second, I will address the question of whether there are circumstances precluding the wrongfulness of acts that are attributable to Israel. And third, I will outline the legal consequences arising out of these internationally wrongful acts. The point of departure for determining the legal status of Israel's occupation of the Palestinian territories is the question of title. Does Israel have title over the West Bank, Gaza, and East Jerusalem? The answer is unequivocally no. Given time constraints, I will only identify the main milestones of Palestine's history. Palestine was under Ottoman sovereignty, and it came under British belligerent occupation during World War I. Then, in 1922, Palestine was placed under a League of Nations mandate that provisionally recognized Palestine as an independent nation under British administration. after which Turkey renounced sovereignty over Palestine pursuant to the 1923 Treaty of Lausanne. This was followed in 1947 by the adoption of the Palestine Partition Plan, which was never implemented. And then in 1948, Britain withdrew from Palestine and Israel unilaterally declared independence, which was followed by armistice agreements in 1949 and the establishment of Egyptian control over Gaza and Jordanian control over East Jerusalem and the West Bank. And finally, in 1967, Israel launched an armed attack, as a result of which it occupied the West Bank, Gaza, and East Jerusalem. At no point in this process did Israel acquire title over these territories. Moreover, theories that support an alleged Israeli title over these territories, such as the claim that the legal status of Palestinian territories was indeterminate, or that there was a sovereign vacuum that Israel was entitled to fill, are entirely unfounded. Accordingly, since 1967, Israel has exercised belligerent occupation over the West Bank, Gaza, and East Jerusalem. The African Union also submits that Israel's 57-year occupation of the Palestinian territories is unlawful and must be brought to an end. This determination is based on three arguments. First, as the overwhelming majority of parties in these proceedings have argued, Israel's occupation is unlawful because it violates the prohibition on the acquisition of territory by force, which is a corollary of the prohibition on the use of force. This constitutes a violation of a peremptory rule of international law. The evidence on this point is incontrovertible. Pronouncements by Israel's political leaders and the conduct of Israel on the ground reflect an intention to perpetuate the occupation through acts that amount to de jure and de facto annexation of Palestinian territories. Israel's conduct in the current hostilities in Gaza also demonstrates its goal of entrenching its occupation of Gaza. Israel is reportedly planning to establish permanent buffer zones, maintain a long-term active military presence on the ground, and is striving to displace the population of Gaza to neighboring states. This conduct, which has been roundly denounced by the African Union, confirms Israel's intent to acquire and annex further Palestinian territory in Gaza. Second, also as the overwhelming majority of parties have argued, Israel's occupation is unlawful because it deprives the Palestinian people of their right to self-determination. It is uncontested that the Palestinians are a people that are entitled to exercise self-determination. It is also established that self-determination is a right that is exercised in relation to a specific territory, and that it is unlawful to disrupt the unity and integrity of the territory in relation to which the right to self-determination is exercised. In the present case, the territories on which the Palestinians are entitled to exercise self-determination are the West Bank, Gaza, and East Jerusalem, which constitute a single, indivisible territorial unit. Violating the right to self-determination also constitutes a violation of a peremptory rule of international law. Third, the cumulative effect of Israeli policies and practices that are associated with the occupation provides an additional basis on which to conclude that the occupation is, as a whole, unlawful. This is a point that deserves to be highlighted because it has been argued that violations of the law of belligerent occupation do not affect the legal status of the occupation. Specifically, the United States claimed, and I quote, that international law does not provide for an occupation itself to be rendered unlawful or void based either on its duration or on any violations of occupation law. This view is incorrect. The violations of international law committed by Israel in the occupied territories constitute continuing and composite breaches of international law. Specifically, Articles 14 and 15 of the ILC Articles on State Responsibility provide a basis for establishing that separate and distinct violations of the law of belligerent occupation can, when combined and viewed cumulatively, lead to the conclusion that the occupation as a whole is unlawful. Article 14.2 of the Articles on State Responsibility defines a continuing wrongful act as one that continues in time and remains not in conformity with an international obligation. According to the ILC, examples of a continuing wrongful act include, and I quote, the maintenance by force of colonial domination and unlawful occupation of part of the territory of another state. This confirms the relevance and applicability of this concept to the case of Palestine. Other examples of Israeli practices amounting to continuing breaches include settlements in the West Bank and East Jerusalem, the separation wall, the network of bypass roads, legislative acts purporting to annex portions of the Palestinian territories, and the exploitation of water resources in the West Bank. In addition, internationally wrongful acts that are attributable to Israel should be viewed as composite breaches of international law. As defined by Article 15 of the Articles on State Responsibility, composite acts are made up of a series of actions or omissions defined in aggregate as wrongful. This does not exclude the possibility that every single act in the series could be wrongful in accordance with another obligation. As the ILC explained, the concept of composite breaches is intended to address situations where the responsible entity, including the state, adopted a systematic policy or practice, and that is precisely why the concept of composite breaches is valuable in the present case. It captures the fact that Israel's conduct is not composed of random or isolated wrongful acts. Israel is pursuing a systematic policy that is designed to perpetuate its control of the Palestinian territories. For example, the establishment and expansion of Israeli settlements and the transfer of over 700,000 Israeli settlers to the occupied territories is wrongful under Article 49 of the Fourth Geneva Convention. Similarly, the construction of a bypass road is wrongful under Articles 46 and 52 of the 1907 Hague Regulations and Articles 49, 52, and 53 of the Fourth Geneva Convention. However, in addition to violating these specific rules of international law, the settlements, the bypass roads, and the separation wall and other practices are elements of an Israeli policy through which it is seeking to gain permanent control of the occupied territories, making it impossible to restore the status quo ante bellum. These Israeli practices, when viewed in their totality, make the occupation unlawful because they constitute composite wrongful acts that violate the prohibition on the use of force, the prohibition on the acquisition of territory by force, the prohibition on systematic racial discrimination, and the Palestinian people's inalienable right to self-determination. Mr. President, distinguished members of the Court, I will now address the question of whether there are circumstances that preclude the wrongfulness of Israel's conduct. Specifically, I will argue that Israel cannot validly invoke the right to self-determination, the right to self-defense to justify its occupation of the Palestinian territories. In this regard, the historical record is unequivocal. Israel's occupation of the Palestinian territories was a result of an act of aggression that commenced on June 5, 1967. Moreover, it should be recalled that international law does not recognize a purported right of anticipatory, preemptive, or preventive self-defense. The terms of Article 51 of the Charter are unambiguous. The right to self-defense is triggered, quote, if an armed attack occurs, end quote. Indeed, the Organization of African Unity declared on numerous occasions that Israel's use of force in 1967 amounted to an act of aggression. It should also be recalled that in the Wall opinion, the Court determined that Article 51 of the Charter has no relevance where the alleged threats invoked by Israel to justify its conduct originate from within, not from outside, the occupied territories. And even if one were to assume arguendo that Israel may invoke the right to self-defense as a circumstance precluding wrongfulness, which it cannot, it is patently clear that self-defense cannot justify Israel's practices. Self-defense is a narrowly construed exception to the prohibition on the use of force. Israel's practices that are designed to perpetuate its occupation can never satisfy the requirements of necessity and proportionality. Furthermore, as several states have already affirmed in their pleadings, the exercise of self-defense can never provide a valid basis for acquiring title to territory that is occupied as a result of the exercise of the right to self-defense. Moreover, given that many of the internationally wrongful acts attributable to Israel are violations of rules of jus cogens, it is our submission that self-defense cannot be invoked in this context. Article 26 of the ILC Articles on State Responsibility and Article 18 of the ILC Conclusions on Identification and Legal Consequences of Peremptory Norms of General International Law are clear. Quote, where the responsibility of a state for a breach of a peremptory norm is invoked, the state against which the breach is invoked cannot excuse itself from responsibility by raising any circumstance that might ordinarily preclude its wrongfulness. In short, the African Union submits that Israel cannot invoke self-defense as a circumstance precluding wrongfulness. Finally, Mr. President, distinguished members of the Court, I will turn to the question of the consequences arising from these internationally wrongful acts. The ILC Articles on State Responsibility affirm the customary principle that, quote, every internationally wrongful act entails the international responsibility of the responsible state. It is on this basis that in the Chagos opinion, after the court determined that the United Kingdom's continued administration of the Chagos archipelago constituted a wrongful act, it was held that the United Kingdom was under an obligation to bring an end to its administration of Chagos, quote, as rapidly as possible, thereby enabling Mauritius to complete the decolonization of its territory consistent with the right to self-determination. The same is required here. Israel must end its unlawful occupation of all the Palestinian territories as rapidly as possible in order to enable the Palestinian people to exercise their fundamental right of self-determination. This is the request that the majority of parties participating in these proceedings have made. The United Kingdom, however, is a notable outlier on this point. It argues that if the court were to address the status of the occupation and require Israel's withdrawal, that would undermine the Security Council's framework that is premised on reaching a two-state solution through a process of negotiations. The African Union does not agree. To condition the end of occupation on a negotiated settlement is to make the occupation permanent, given that the occupying power, Israel, refuses to negotiate on the basis of the two-state solution. And it has declared its will that it will never accept the establishment of a Palestinian state. Those states that purport to support the two-state solution ought to endorse calls for this court to unequivocally determine that Israel's occupation of the Palestinian territories is unlawful. This is especially necessary given the peremptory nature of the right to self-determination and the prohibition on the acquisition of territory by force. The modalities necessary to end the occupation as rapidly as possible could be decided under the supervision of the relevant organs of the United Nations. Israel's unlawful occupation of the Palestinian territories also gives rise to consequences for other states, including the customary legal obligations reflected in Article 41 of the Articles on State Responsibility, which are, 1, not to recognize any benefit accruing to Israel from the unlawful occupation, 2, not to lend aid or assistance to Israel that might further the occupation, and 3, to cooperate to end the unlawful occupation and to protect the right of self-determination of the Palestinian people. It is perplexing that the United States has challenged the customary status of Article 41. This long-established principle has been recognized by the court itself in the Wall Advisory Opinion and by the UN Security Council. It was even applied by the United States in 1932 in the context of the Japanese aggression against China in what was known as the Stimson Doctrine. Pursuant to this doctrine, the United States government declared that, quote, it cannot admit the legality of any situation de facto, nor does it intend to recognize any treaty or agreement that impairs the sovereignty, independence, or territorial integrity of China. The court should uphold this principle. In its written statement, the African Union offered various specific ways in which states may practically and meaningfully comply with these obligations of non-recognition, non-assistance, and cooperation. The African Union simply wishes to emphasize that occupation and self-determination cannot exist at the same place and the same time. If occupation is illegal, it must be ended to permit the recognition of self-determination. In closing, Mr. President, members of the Court, the African Union reiterates its call to end Israel's occupation of the Palestinian territories. The injustice being wrought against the people of Gaza, as we convene here in the Great Hall of Justice, makes it imperative to end Israel's impunity and hold it accountable to the rule of law. The court of history may very well judge the credibility of international law on the basis of the outcome of these proceedings. The international community has let down the Palestinian people, but the African Union has faith that in this court, justice will prevail. The betrayal of the sacred trust that is the self-determination of the Palestinian people is an enduring injustice that pleads to be remedied. It is the only path towards ensuring a future of security, stability, peace and prosperity for the peoples of a troubled region. Thank you for your attention.
I thank the delegation of the African Union for its presentation. The court will meet again this afternoon at 3 p.m. to hear Spain, Fiji, and the Maldives. The sitting is adjourned.